Hello, my name is Kevin Annett, Eagle Strong Voice. It's Friday, September 22nd, 2023, and I would like to thank the court and its honorable judges for allowing me to appear before it today to give testimony in the second case docket before the court, West Coast Common Law Court of Justice, having to do with the criminal conspiracy and assault against myself based on legally uncontested facts and evidence. And I want to start by saying that I'm particularly thankful to be appearing here on the territory of the traditional Squamish and Musqueam people, and especially in memory of my friend and fallen, murdered comrade and associate, Harriet Nahani, one of the early witnesses to the crimes of genocide in Indian death camps called residential schools, the cause for which I have suffered so much over the last 30 years. My case is a spotlight on the bigger crime that has not gone away and is only intensifying. And for that reason, the facts and evidence of my case are especially important for all people. I want to begin by reminding the court that a lot of the things I'll be discussing, the documents, all of the hard evidence is found not only in murderbydecree.com, but in my most recently published book, Crimes Against Humanity in Canada, the Evidence, and especially Part 3, which documents in detail my targeting by the United Church and the government and other forces after I began to bring up these crimes in 1995, after my expulsion from the United Church. It also contains the history of our movement that brought out the crime of genocide and the crime itself. And I will provide, of course, all of the accompanying evidence and testimonies and documentation to the court as part of the docket of evidence. Let me give, first of all, the general facts and details of my case. I was a former ordained minister of the United Church of Canada, who was ordained in 1990. As a married man with two small children, I became the minister of St. Andrew's United Church in Port Alberni, British Columbia. And I was in that position from July 15th, 1992 to January 23rd, 1995, on which date I was fired without cause. During my Port Alberni ministry, I expanded my congregation from 20 to 100 people and brought Indigenous people into my church for the first time. I opened my pulpit to survivors of the United Church's local Indian residential school death camp. And shortly before my firing, I began to speak about those crimes, as did survivors of those crimes, from my pulpit. And especially the survivors of the Alberni Residential School began to mention children being murdered there and buried in the hills behind the school. Shortly after they began to talk about that from my pulpit, on January 23rd, 1995, I was summarily fired from my position without cause, notice, or review. I was dismissed by two regional church officials who lacked the authority to remove a minister, Art Anderson and Cameron Reed. These men acted under the secret instructions of the chief fiduciary officers of the United Church, at the time Moderator Marion Best and General Secretary Virginia Coleman, also by order of Brian Thorpe, the chief executive officer of the church's BC conference, and John Kishore, who was a provincial government cabinet minister and a United Church clergyman. My illegal removal was precipitated as well, not only by the mentioning of killings in the church's Alberni Residential School, but by a letter I wrote to church officers on October 17, 1994. That letter protested the church's theft and secret sale of land belonging to the Ahousaht Indigenous Nation. The sale of that land to Macmillan Bloedel, which was a financial benefactor of the United Church. In conjunction with its major shareholder, the BC government, Macmillan Bloedel was soon after acquired by Weyerhaeuser Limited, the largest logging company in the world, in the biggest corporate takeover deal in BC history, totaling over $3 billion. In other words, we were stumbling over a secret land deal, very lucrative land theft. United Church officials have subsequently stated on record that I was removed from my pulpit not for any wrongdoing or incompetence as a minister, but because I issued a letter about the Ahousaht land theft and I revealed crimes in the Alberta Indian Residential School, and that's on record, including at my illegal delisting trial that threw me out of ordained ministry. The day after my firing, my wife, Ann McNamee, was approached by United Church official Phil Spencer and United Church lawyer John Jessamine. On behalf of the church, Spencer and Jessamine offered to pay Ann to leave me and to divorce me, to monitor and harass me, and to estrange my children from me, our two daughters, Claire and Eleanor. Ann agreed to do so. She subsequently won legal custody of both our children with the collusion of BC Family Court judges Ronald Barber and Alan Donaldson. Now, Judge Donaldson was a close friend and associate of Bill Howie, one of the United Church officials on Vancouver Island who helped to instigate my removal. Ann McNamee's lawyer, Ron Hunink in Vancouver, was paid at least $36,000 by the United Church to handle Ann's divorce and custody action against me. United Church lawyer John Jessamine arranged my firing and divorce and prevented me from finding other work in the church. Jessamine also blocked my appeals and attempts to negotiate a resolution with my employer, the Comox Nanaimo Presbytery officials. In early February 1996, after I began to protest my firing and I began to gain media coverage, the first Indian residential lawsuits were announced. Indian residential school lawsuits were announced at that same time. And exactly at that moment, when we began to get media coverage about my firing and the residential school crimes, at that point, John Jessamine initiated the process of permanently expelling or delisting me from the United Church ministry. And again, all of the supporting documents and proof of this is found in my accompanying affidavits and other material in the docket of evidence. Well, during the same period, during 1996 and 97, in collusion with the University of British Columbia President Martha Piper, Jessamine arranged the sabotage of the doctoral studies program that I recently commenced at the university, and also blocked my subsequent efforts to publicly lecture on campus about the Indian residential school crimes. During this period, John Jessamine and church official Brian Thorpe also sabotaged my attempt to become an ordained Unitarian minister in Vancouver. And they did that with the collusion of that church's Pacific Northwest Regional Officer Ann Heller and Unitarian minister Philip Hewitt in Vancouver. Jessamine, Thorpe, and other United Church officials were actively assisted in these assaults on me by several other people, including Inspector Peter Montague of RCMP E Division in Vancouver and his Deputy Sergeant Jerry Peters. Both of these officers personally harassed and threatened me after I began to publicly protest the death of Indian residential school children in December 1995. These RCMP officers also colluded with my wife Ann McNamee in these and subsequent black operations against me, as did Thorpe and John Siebert, who was a United Church liaison officer with the RCMP. Finally, on August 29, 1996 in Vancouver, the United Church convened its illegal public delisting trial of me, the first such public delisting of a minister in United Church history, which eventually cost the church over $300,000. Despite his role in my firing, divorce, and blacklisting, John Jessamine served as the chief judicial officer at this hearing. Along with Brian Thorpe, Jessamine handpicked the 3 delisting panel members who would decide whether I would retain my professional ordination. The panel's chair, Molly Williams, was a close friend of Jessamine and had nominated him for United Church Moderator in 1984. Also, the church where they met was owned by a very close friend of Brian Thorpe's, Brad Newcomb. My delisting hearing occurred for about 6 months, between August 29, 1996 to March 7, 1997. The stated aim of the delisting was to consider a motion from Comox Nanaimo Presbytery to place my name on the church's discontinued service list. That would mean I couldn't work as an ordained minister anymore. The onus, however, was on the presbytery to prove beyond any reasonable doubt that I was an unsuitable minister. But paradoxically, the same motion stated that there were no charges against me and I was not under any form of discipline or reprimand. But I had simply been removed from my ministry and prevented from seeking further work in the United Church, quote, for the peace and welfare of the church. But they never defined what they meant by peace and welfare. Comox Nanaimo Presbytery was represented at the delisting hearing by a Catholic lawyer named Ian Benson, who was a friend of John Jessamine. Benson received over $50,000 in remuneration from the United Church for his work in throwing me out of the church. I was legally unrepresented and unpaid, and I was expected to appear at my own expense without being given the cause of the action, any evidence, or the names of my accusers, or any other requirements of natural justice and due process under the law. Now, an independent legal examination was conducted of the delisting hearing after the fact, based on all the evidence and witnesses, and they revealed the following uncontested facts, never been challenged at all by the United Church, these facts. 1, the hearing continually violated or ignored due process and legal rules of procedure. 2, John Jessamine and the panel members demonstrated a consistent bias against me and made openly disparaging remarks about me on the record, including, quote, "We've come to expect this kind of thing from Kevin. And if Kevin doesn't play ball with us, he'll never work in this country again." Both of those remarks made by John Jessamine. And from Molly Williams, the panel chair, quote, "You have only yourself to blame for this situation, Kevin," unquote. Point 3, during the hearing, Jessamine, the panel members, and church lawyer Benson routinely went to lunch together, socialized, and examined copies of the hearing minutes without informing me. 4, the panel members continually allowed hearsay and unsupported allegations to stand as evidence against me and refused my request to know the grounds for delisting a United Church minister, which I needed to have in order to conduct a proper defense. Point 5, none of the 4 witnesses called to testify against me by Presbytery had any first-hand experience of me or my work. One of them, Kathleen Hogman, had never even met me before the hearing. Their statements, in other words, constituted hearsay and therefore were inadmissible, not only under the law, but under the panel's own rules of procedure. But nevertheless, the panel declared them to be admissible. Point 6, none of the witnesses called by me in my defense were allowed to appear before the panel, nor were any of the 38 letters of recommendation for me that I submitted as evidence. 7, against rules of legal procedure, John Jessamine continually halted the proceedings whenever I asked Presbyterian witnesses questions about Indian residential schools or stolen native land, even though Jessamine acknowledged that those were the issues and the reason behind my firing. Point 8, under cross-examination, Comox and Nanaimo Presbytery officials Bob Stiven and Wynne Stokes stated on record that my removal had never been discussed or put to a vote in the Presbytery, and therefore my firing was illegal under United Church regulations. Stiven and Stokes also admitted and stated on record that I had done nothing wrong, I faced no charges, I was simply setting church policy when I objected to the house and land deal, and that Presbytery had, quote, no concerns about Kevin until I wrote the letter about the land issue. Point 9, evidence submitted by me revealed that in April 1996, National United Church leaders Marion Best and Virginia Coleman had met with officials of the New Chelmsford Tribal Council in Port Alberni and paid them to attack and undermine my investigation into the death of Alberni Indian residential school children. This plan was facilitated by Brian Thorpe and his fellow official John Siebert. According to Bruce Gunn, who was present at the meeting, quote, "The payoff deal Best and Coleman made with the West Coast chiefs is responsible for the present delisting actions against Reverend Annett. The issue before us is therefore not one of Kevin's suitability for ministry, which has been amply proven, but rather the Church's efforts to silence an inconvenient whistleblower. I am convinced that Reverend Kevin Annett is the target of a definite criminal conspiracy by the United Church and others that is seeking his professional and personal destruction," unquote. Point 10, other evidence submitted by me in the hearing revealed that it was John Jessamine himself who was responsible for stopping Presbyterian negotiations with me after my firing when we were on the verge of a resolution, and thereby provoking my delisting. Accordingly, Jessamine was compelled by legal procedure to step down as judge of the hearing because of a clear conflict of interest. I asked him to do so, and he refused. Under legal advice, I then left the hearing, at which point the panel chair Molly Williams, yelled at me, quote, "If you leave now, Kevin, you will face dire consequences," unquote. One of the few truthful things that was said in that hearing. And finally, point 11, the delisting hearing, believe it or not, then continued without me being present. At no point prior to or after my departure from the hearing did Presbytery lawyer Benson ever present any evidence that proved Presbytery's case, namely that I was unsuitable for United Church ministry. On the contrary, the bona fide evidence indicated otherwise. Nevertheless, with no basis in fact or evidence, the panel voted on March 7, 1997 to delist me and expel me from United Church ministry. There was no appeal allowed, and that concluded the hearing. Well, soon after this farcical delisting hearing, the government continued to assist these church attacks against me by helping to strip me of my legal rights and civil liberties. The Attorney General of British Columbia, Ujjal Dosanjh, who was a cabinet colleague and friend of John Kishore, who had instigated my firing, Dosanjh refused to review the fraudulent delisting hearing. Responding to 22 letters of protest from eyewitnesses to my delisting, Ujjal Dosanjh falsely claimed in writing that, quote, the internal disciplinary processes used by churches are outside the jurisdiction of this ministry, that is, outside the laws of Canada. Now, Dosanjh falsely stated that these were disciplinary hearings, and also, a few years later, he continued to use his office for criminal purposes by appointing a known child trafficker and child rapist, Chief Ed John, as the Minister of Children and Families for British Columbia, and Dosanjh then threatened lawsuits against anyone who challenged that cabinet appointment. Well, that kind of corruption and official state sanction of the United Church's fraudulent show trial and my professional destruction, it encouraged a new round of state-level assaults against me. These RCMP and church-led attacks intensified during 1998 when I and residential school survivor Harriet Nahani launched a public campaign to prosecute and expose genocide in the residential schools. And that high point in that was on June 12, 1998 in Vancouver, when we convened a United Nations-sponsored tribunal into the residential school genocide, the first such inquiry ever held. This event won international attention, but also provoked an expanded campaign of state terror against us and our work that involved the Canadian government and even the office of Prime Minister Jean Chretien. For after the tribunal garnered media coverage outside Canada during the summer of 1998, Prime Minister Jean Chretien ordered the destruction of Indian residential school records and the disinterring of mass graves of children near the schools. He also authorized covert actions against me, Harriet Nahani, and Indigenous activists on the West Coast. Sources state that these directives were issued on August 12, 1998 in a confidential communique Chretien sent to the Privy Council office in Ottawa. These covert actions were implemented and coordinated by RCMP Inspector Peter Montague and a former FBI informant and provocateur named James Craven, who had infiltrated the tribunal in Vancouver as a judge. Craven began the first internet smears against me, spread information about me and Harriet, and paid our supporters to spy on and denounce us. The RCMP were assisted in this by the same Chief Ed John of the Carrick County Tribal Council, who sent strong-arm operatives to assault me during the June 1998 tribunal and eliminate eyewitnesses. And I know that for a fact because a man named Dean Wilson, who worked for Ed John, grabbed me by the throat on the first day of the tribunal, threw me against a wall and said, Eddie John doesn't like what you're doing. He says, cut out all this talk of res school kids or you'll get it worse, unquote. The covert operations against me and Harriet intensified during the subsequent decade as we established our own Truth Commission and rallied genocide survivors across Canada in high-profile public protests, conferences, and church occupations. These escalating covert operations were aimed primarily at me as the main spokesman of the movement. They included a broad spectrum assault on me, my children, friends, and associates, my public actions and livelihood, and my public and media image, a blacklisting and smearing that continues to the present day. This state-level assault represented the first major effort by Canada to censor, misrepresent, and decriminalize its domestic genocide and murder of more than 60,000 Indigenous children in the residential schools. It included silencing survivors with hush money, destroying grave sites and other evidence of the crime, restricting legal action against the Catholic, Anglican, and United Churches, muzzling the press, and eliminating natives who would not cooperate with this cover-up, especially residential school survivors working with me. Between 2007 and 2012, 7 Indigenous allies of mine were killed while in the hospital or police custody. And that's covered in detail in the first case docket before the honorable judges. By 2003, these attacks had censored my name and work from the Canadian media, and had ostracized me in the academic world, where I was banned from campus speaking after my PhD had been blocked at UBC, and my books were removed from course curricula in local libraries. But my unswerving efforts to publicly confront the guilty churches eventually forced the Canadian government to publicly acknowledge the Indian residential school genocide. It did so on a date of statutory significance, June 11, 2008, one day before the 10th anniversary of the seminal June 12, 1998 tribunal. Canada's June 2008 apology for Indian residential schools began the institutionalization of the official cover-up. It did so by legally indemnifying the government and churches for their proven crimes against humanity, banning and censoring me and my work across Canada, and creating a false substitute narrative about the residential school genocide. This dissimulation manifested in the misnamed Truth and Reconciliation Commission, established by the guilty government and churches in direct response to my campaign in order to nullify its impact, fog and decriminalize the genocide, and exonerate the perpetrators. Undergoing a subsequent night and fog public erasure within Canada as part of this cover-up, I then expanded my work to Europe during 2009 and helped establish the International Tribunal of Crimes of Church and State, the ITCCS, in June 2010 in Dublin. But this heightened campaigning drew even greater repression down on me and my supporters after we began protesting at the Vatican and in London, and after we launched a court action against Pope Benedict, Queen Elizabeth, and others that caused Benedict's resignation on February 11, 2013, the first such resignation in over 600 years in the Vatican. Intelligence sources indicate that the escalated covert operations against me and our movement were organized by the Vatican spy and assassination agency known as Santa Alianza, in collusion with MI6 and the RCMP. These agencies were responsible for the sabotage of the ITCCS and its courts, the deportation of me from England in May 2011, and the death or disappearance of 4 ITCCS activists in Europe and 7 of our Indigenous allies in Canada during this period. In addition, Santa Alianza was implicated in my near-fatal chemical poisoning during the summer of 2021 when I was on a speaking tour in Eastern Canada. While the systematic criminal assault on me since January 1995 constitutes a single litany of permanent church and state terror that nearly beggars description and imagination, the evidence of these assaults reveals that they recurred routinely, intensifying whenever I began to make public headway in the campaigns. And an example of this is the concerted attacks against me by church and state occurred whenever I first began to bring out these truths. For example, when I first exposed the Indian residential school crime and the United Church theft of a house and land in 1995 and 6, when I launched the first residential school tribunal in 1998, and the first Truth Commission into genocide in Canada in 2001, when I began the national church protests and occupations between 2005 and 8, forced Canada's public admission of genocide in June 2008, launched the ITCCS in Europe in 2010, conducted the first excavation of a mass grave of children's remains at the Anglican Mohawk School in Brantford, 2011-2012, convened common law courts that prosecuted and forced into resignation Pope Benedict in 2013, helped establish Republic common law courts and assemblies across Canada 2020 to 2021, and finally launched our recent campaign to expose and prosecute the ongoing genocide of Indigenous people in Western Canada by China, the Crown, and the Vatican in 2022 and 2023. All of these incidents provoked increasing attacks on me and my followers. According to a source within the RCMP, whose statement you have in your docket of evidence, quote, "I don't exaggerate when I say that millions of dollars and dozens of operatives have gone into discrediting and shutting down Kevin Annett since the 1990s. It's been one of the biggest badjacking operations in our history," unquote. Well, these uncontested facts indicate that I am a targeted and persecuted political prisoner in exile in my own country. I am unable to get employment, establish any security, conduct my public work in human rights campaigns, or pursue a free and unimpeded life because of a permanent criminal conspiracy being waged against me. That conspiracy originated and is maintained and directed by the highest levels of church, state, and corporate power in Canada and abroad, and by their agents, some of whom are named in this public indictment. Accordingly, I name the following people as defendants in this case as the people who are culpable participants in the criminal conspiracy and assaults against me. I name the following: Jean Chretien, former Prime Minister of Canada; Jorge Bergoglio, Chief Bishop of the Church of Rome; Domenico Gianni, Director of Santa Alianza; Ojel Desange, former Attorney General of British Columbia; Marion Best and Gary Patterson, former moderators of the United Church of Canada; Virginia Coleman, former General Secretary of the United Church; and the following officials or clergy of the United Church: John Kishore, John Jessamine, Brian Thorpe, Molly Williams, John Siebert, Phil Spencer, Foster Freed, Brad Newcomb, and John Maba; the estates of the deceased officials of the United Church: Art Anderson, Bill Howie, Cameron Reed, Fred Bishop, Terry White, and Bob Stiven; Michael Miller, Archbishop of the Roman Catholic Church; Fred Hiltz, former Primate of the Anglican Church of Canada; Ronald Barber, former Master of the Supreme Court of British Columbia; and Alan Donaldson, former Justice of the Supreme Court of British Columbia; Ron Hunick and Ian Benson, lawyers with the British Columbia Law Society; Peter Montague and Jerry Peters, officers of the Royal Canadian Mounted Police E Division in Vancouver; and James Craven, RCMP operative; Ed John, former head of Carrier-Sicani Tribal Council; Martha Piper, former president of the University of British Columbia; and Neil Guppy, former professor at the University of BC; the estate of Murray Elliott, deceased professor from UBC; Anne Heller, an official of the Unitarian Universalist Church; and Philip Hewitt, deceased former clergyman of that church; and the individuals Anne McNamee, my former wife, and Jack Thornburg. This indictment and charges read as following: I accuse these people of having done three things: planning and participating in a criminal conspiracy to assault, denigrate, and destroy my life, work, family, public reputation, and good name, and my civil liberties, deliberately and with malice aforethought. 2, planning and participating in my attempted murder and the successful murder of my associates, and in the destruction of their efforts and campaigns to expose and prosecute genocide and child trafficking and killing in Canada and abroad. And finally, 3, actively engaging in and concealing these crimes to enable and protect the perpetrators of ongoing crimes against humanity in Canada and abroad, and to obstruct and deny justice. Accordingly, I recommend to the court that summonses be issued against these people to appear before you on Monday, October 16th at 10 a.m. in the city of Vancouver. I urge the court to take action for the sake of justice. This is Kevin Annett, Eagle Strong Voice. I thank you for your indulgence today.